This is WAAY 31 Law Call.
Good evening and welcome to WAAY 31 Law Call. I'm Sharon Doviet. It's Ask Us Anything night. It's also our anniversary, 30 years of Law Call on the air. Well, if you're enjoying the summertime, but you've got something nagging in the back of your mind, some legal problem that you need to get solved, tonight's the night to call in and ask. Everything from car accidents to contract disputes to custody cases. You can call in and be live on the air, 256-536-0077. Call in, or you can text and be on the air with us, or email us your questions. You send it to lawcall@waytv.com, and when we get to a show that's on point, we pull some out. We've got some of your email questions tonight. We've also got Heath Brooks here from Timberlake League and Brooks. Good to have you here.
Nice to be here. 30 years.
30 years. Now, neither one of us have been there since the very beginning, but Heath has been here for quite a long time.
I have.
Going back to 2008.
Yeah.
Check this out.
Yeah.
As an example, when I was growing up, I grew up on a farm, and we had a bunch of old wells on our property. And a lot of times you would see people just cover an old well with some old 2x4s or pieces of timber. And one thing that would be a situation if somebody's coming on your property, they can never find that well. You would really need to tell somebody about that well, and if they fall in it, you could be liable.
You haven't aged a bit.
No, I haven't. I look exactly the same. No silver or anything like that.
Nothing's changed. Do you remember the first couple of shows? It's a little intimidating. You look and sound great.
I
but it's a little scary the first time you come on.
It is. Deer in headlights. I think that's about a deer in headlights, yeah.
You've had every kind of question.
Yeah.
Deer in headlights, I'm sure, has been one of the questions at one time.
Yes.
Neighbors, we'll talk a little bit about neighbor
Right.
situations and everything from the kinds of questions that we get calls in about.
Right.
Trees, property lines, hitting an animal on the road. You know, there's a new law. We're going to talk about all kinds of things, including some new laws,
right.
a new law in Alabama. So happy anniversary. That's
Thank
great.
you so much. 30 years. That's great.
Let's talk about, there is a new law, and this is Alabama's new Bowes Law. What is
Bowes Law, yeah. So, you know, it's the first of its kind that deals with the protection of an animal. And this came out of a dog that had been mistreated during the winter and was actually stuck out in the cold and the snow. And Bo was the name of this dog, who is now in a happy home. But his story went all over the country, and it prompted some activists in Alabama to move forward to try to encourage the legislature to pass a law that protected dogs. And so what ended up happening out of this law is it was just passed. It's called Bowes Law, named after this dog, and it requires owners of dogs to not tether their dog or chain their dog to a tree without having the yard enclosed completely, without having clean water, without having good food to eat, without having a shelter. And there are requirements within the statute for all these things. Good. Like, in other words, the tether can't be a choke collar.
Yeah.
The shelter has to have a solid bottom. It can't have stuff inside. It's got to have blankets in the cold. It's got to be ventilated. There are some requirements in the bill so that it keeps these animals as humane as possible and prevents, you know, the times when you see a dog chained to a tree in the cold and emaciated and starving. So hopefully it'll help out.
We're big animal lovers here,
Yes,
so
we
like to see those things.
Don't like to see that.
We've got callers waiting. We've got Carl on the line with a question or comment from Rainsville. Hi, Carl. Thanks for calling. What's your question?
Hey. I'm just wondering, I got a few vehicles, and do I need to change the title over before I pass away, or, you know, how do you do that?
So vehicles so who would you want to leave them to?
Right.
Do you know?
To nieces and nephews.
Yeah.
I have no wife and kids, so.
Okay.
Okay, Carl, so the first thing that you would need to do is make sure that you have an appropriate will. So regardless of whether you change the title over to the car, then you need to make sure that in your will it designates where you want your property to go. Because if you die without a will, you die intestate. And in Alabama, there are certain laws that are going to govern where your property goes, and it may not be to the people that you wanted to go to. The other thing is that when you pass away, everything that you own, including your cars, your personal property, your land, it goes into an estate. And you may owe people money. You may owe companies money. You still may have a mortgage on your property, or whatever the case may be. So all of those debts are going to be paid out of your estate first before any of your personal property gets distributed to your nieces and nephews. So if you don't want that to happen, you can go ahead and deed your property now to your nieces and nephews if you wanted to do that.
We've got Chad on the line with a question from Madison. Hi, Chad. Thanks for calling. What's your question tonight?
Yes, ma'am. I was recently received a cease and desist letter from an HVAC contractor that I actually used to work for, and I've got non-solicit, non-compete with them.
Okay.
And they've actually turned out to be, they have a suspended HVAC license, and
Oh, I think we lost you there. A cease and desist letter. Carl, Chad, you still with us? A cease and desist letter from a prior employer.
Yeah, and and I think maybe what he was getting at is that now this private employer is no longer in business. So does the cease and desist letter continue to be applicable if that company's no longer in business? And so I would say this: when you enter into a non-compete clause in exchange for employment, sometimes those clauses aren't valid. Under Alabama law, there's a strict set of guidelines that have to be followed in order for those non-compete clauses to be valid in the first place. So the very first thing you need to do is ensure that that was a valid non-compete clause. And a lot of times you need to talk to an employment lawyer or get in touch with a lawyer who handles those kinds of issues. But then your second question is, the purpose of a non-compete is so that you don't compete with the business that you work for and take their business. There is a real question. If that business is no longer in business, whether there is any contractual provision there that exists any longer. So that's something that you would need to address with an attorney, but there's some real question about whether that non-compete would still be applicable in the event that the company you work for is no longer licensed.
Sounds like a bar question.
It does.
This one plus this one.
Yep.
Okay, we got in a text question. Somebody was asking about if you were involved in an accident and the lawsuit is won, but the person who was in the accident passes away. What happens to the money?
Well, that's we talked
That
about
happens,
our estate.
doesn't it?
It happens all the time, and we talked about our estate issue earlier. And this happens in bankruptcy situations too. If somebody owes you money and they go bankrupt, what do? Well, if somebody passes away and they still owe you money, either from a judgment or after a lawsuit, or maybe they just owe you money because you sold them something you haven't been paid yet. What you've got to do is you've got to put the court on notice. The probate court is where wills are probated, and that's where a will is handed to the probate judge, and the judge begins the probation process and establishes a personal representative to administer all of the assets of that person who passed away, their estate. And so in that kind of scenario, you got to call up the probate court and file the appropriate paperwork to get in line to try to get your judgment paid out of the estate before it goes to all those other people who may have an interest in the estate.
Okay, another text question. How long does a power of attorney last? Okay, so first off, what is a power of attorney?
So there's a whole bunch of different types of powers of attorney. Powers of attorney can grant you an individual thing, or it doesn't have to be an attorney. Okay. That's a legal term of art. It can grant an individual person the ability to do something for someone else when they're not able to do it. So those are specific powers of attorney. A durable power of attorney is one that grants the authority to do things like manage your checkbook, manage your bills, take care of you in the event you can't take care of yourself. Those kinds of things, all powers of attorney end when that person who gave the power of attorney passes away.
Okay. Somebody's texting in, can I request a judge who's not in my same county due to a person who works for a legal team in my county? Okay, so can you get a judge removed?
You can get a judge removed, and I'll answer that question first.
Be careful, though.
No, you can't specifically request a judge.
Okay.
That cannot happen. What you can do is you can file, if the judge is so personally related to the individual you have a dispute with, or to the company that you have a dispute with, then you can file a motion to have the judge recuse himself or herself. And that is sometimes playing with fire in a situation where if the judge refuses your request and then hears your case, you may have an issue there. But there is a procedure. If the judge is too close to either of the parties, that judge can recuse himself. And I'll tell you, a lot of the times, judges don't want to get involved in a situation where they have a personal interest in it, so they'll go ahead and recuse themselves anyway, and another judge will come in. That's been my experience.
Sometimes even before anybody asks, they'll say, I'm out, I know too much about this.
Most judges, and I know the judges in our county, really pay attention to those kinds of things.
Yeah.
They don't want to be involved in a case where they know either of the two parties or have some business interest there.
Yeah. We're going to take a break. We'll be right back answering more of your questions for Ask Us Anything night. Stay with us.
Firewood.
which pays an advertising fee to this station.
You're watching WAAY 31 Law Call, the Tennessee Valley's only live legal call-in show for 30 years and counting. Presented by the award-winning personal injury and wrongful death law firm Timberlake, League & Brooks, featuring the knowledge and experience of attorney Michael Timberlake, attorney Will League, attorney Heath Brooks, attorney William Meservey, attorney Bobby Marsh, and hosted by family law attorney Sharon Doviet. Your rights, your calls, live. This is WAAY 31 Law Call.
Welcome back to 31 Law Call. It's Ask Us Anything night, so call in your questions or text in. Be live on the air with us. It is the 30th anniversary of Law Call. Been on the air that many years, but we've got a picture. Heath hasn't been here all of that time.
Again, still, I mean, 2008 I hadn't changed, 1996 I hadn't changed. Ageless wonder, right?
It's looking good. Can you imagine this show answering your questions since 1996? It's great.
I was on my way to a concert in Statesboro, Georgia.
In that picture?
In that picture, yeah. Different world, different life, different time, you know.
We appreciate everybody that watches. We had a viewer, Dorothy, a shout out to Dorothy, who's having her 97th birthday and is a big fan of Law Call and watches every week. Thank you, Dorothy. We really appreciate it.
Happy birthday, Dorothy.
Call in your questions. I hope she's called in a question at some point.
Absolutely.
We had a question, a text come in about a joint custody agreement.
Right. I have a joint custody agreement with my child's mother, but she is not following it. I would like to know what process do I need to do so I can be able to see my children. And Sharon, what do you think about that one?
Okay, so I do family law and we have this come up all the time. You may need to go through the steps of actually having a contempt case filed. You can try to do that yourself, but it is pretty challenging to do. You're probably going to need to have a family lawyer file it for you. Just know that there are a lot of powers that our judges have. Somebody can get 5 days in jail for every act of contempt.
Whoa.
So if they're withholding the child from you 3 days, you're talking about 15 days in jail, possibly. Now, a lot of our judges won't necessarily just lock them up right away, but they will give them a big scolding and maybe find them guilty, give them 15 days. hold that over their head saying, if you don't follow this order, you've got to be absolutely perfect or you're going to serve not only those 15 days, but any more that you mess up.
Do you need an attorney to ensure that the order is followed? I mean, how do you start that whole
You're
thing?
going to file a petition for contempt.
Okay.
And you're going to show the judge what the previous order was. You do need to have all your evidence, so get all your ducks in a row and be ready. You know, I hope that you've been able to talk to the other parent, because it's an expensive process. If you're trying to do it on your own, it's a challenge. And backing up and improving that relationship after you've taken them to court, trying to get them locked up and give them jail time.
Yeah.
Just be very clear with them. You mean it. You want your custody. You want your time. Be sure that you've got a trail, text messages, emails with them to prove that you have tried to get your child for the proper custody time.
You know, we say that with evidence in our world.
You got to have the evidence.
You got to have the evidence, and you know, oftentimes we're dealing with that. Like we get in front of the judge, and we're like, oh, we wish we had this evidence. We wish we had that. I mean, it's critically important to make sure you're keeping your text messages. Make sure I mean, in our case, we keep photographs. You know, we take photographs. We go to a scene. We investigate. You know, those kinds of things, so that like when we get in front of the judge, you know, you have your T's crossed and your I's dotted.
Because what I expect will happen is the other parent, if it's the mom, is going to say, you didn't come to the house to get them. Okay, so now can you prove your case or can you not? Did you do everything that you were supposed to do? Meet with a lawyer and go through it and try. We got an email question. Let me give you this email question from Douglas. I'm about ready to sit down and settle my auto accident claim with the insurance company. Who goes first? Do I tell them how much I want, or do they tell me what they're willing to pay? Okay, what do you recommend when you're trying to negotiate? Or do you even go in without a lawyer?
I think about that show Pawn Stars, and I don't know if you've ever seen that show, but there's this show Pawn Stars, and the guys go in there and they got something, you know, and they're showing it to the guys behind the counter, and you'll notice that the guys behind the counter never make the first offer. They're always like, what are you looking for? What are you looking for? What are you looking for? And so,
because,
you know, then you're like, okay, well, I'll, you know, take $500. You're crazy. I'd never pay anything like that, you know? And so there's a negotiation strategy to not making the first offer. Then in my business, sometimes there's a situation where you do want to make the first offer for legal reasons to ensure that an insurance carrier has the appropriate coverage and things of that nature. So there is a time when you want to make the first offer, and there is a time when you need to let them make the first offer. And I can go ahead and tell you that a lot of that is a negotiation strategy. And anytime you're dealing with a situation where you're trying to negotiate with an insurance company, I would strongly suggest you contact an attorney who does those types of negotiations and can advise you, hey, look, we want to make the first offer here, or hey, let's get them to make the first offer. And that's going to depend upon the circumstances, the level of the injuries, the type of injuries you're dealing with. Is this a property damage case? Is this a personal injury case? Those can be two different things and two different strategies. So it is a strategic thing to deal with insurance companies, and it generally takes some advice from somebody who does that type of negotiation on a daily basis.
We've got Angela on the line with a question from Decatur. Hi, Angela. Thanks for calling. What's your question tonight?
Hello. My question is, I have homeowners coverage for my home, and my homeowners insurance is saying that the cost of coverage is less than my deductible. So how do I go about debating with them on this?
That your cost of coverage is less than your deductible. Does it?
Yes.
She's trying to get a roof repaired.
My cost of coverage, my deductible is $3,000, and the amount of loss is $850.
Okay.
Even though it's my whole roof.
Okay. Yeah, Angela, this is something that, and I think we were talking about this on the last show I was on. This is something we're seeing more and more of, particularly in this part of the country, where you have a lot of hail damage, wind damage, things of that nature, and you'll have a roofer come out and they'll do a estimate on your roof that is going to be significantly different than what your insurance company says. Your insurance company comes out and says, oh, it's just 2 shingles missing. We'll replace those 2 shingles, $850. Meanwhile, you got 3 other roofers saying, no, we got roof damage all over the place, or this is a significant section. We're not going to be able to blend this stuff in. And so they're estimating tens of thousands of dollars sometimes, and insurance companies saying $850. This is an issue that we're dealing with specific insurance companies, specifically in this part of the country, because of the wind and the hail. They try to get out of the damages. that's when you probably need to contact a lawyer on and discuss what your options are. They can't do that. That's not something, depending upon what your insurance policy is, an insurance company can't just say, sorry, your roof's worth $850, it's 2 shingles, when you've got a bunch of other estimates that indicate, no, that's not the case from other professionals. That's a dispute you have with your insurance company, and it's probably going to take some further action.
Good luck with it, Angela. We got in a text question. Somebody's asking about, they've been paying the taxes on land for a really long time. Can they now own it? I've paid taxes on land for 12 years. That was my grandfather and mother, I guess grandfather and grandmother's land. Can I get a survey done and put it in my name? My grandfather passed without a will.
Well,
just because you're paying the taxes doesn't mean you're entitled to it, though,
no,
right?
No, it doesn't, unfortunately. I mean, that may be one aspect that could give you some sort of title or responsibility to the property. A lot of times if your grandfather didn't have a will, his land is going to pass intestate. So it's going to pass to either his children, their children's children, maybe you have a piece of the property. And what ends up happening is if you've been paying taxes on the property for a number of years, then if that land ever does go to those other landowners, they may have to pay you back. You may be able to put a tax lien on the property. There are some options that you may have, but it doesn't guarantee a transfer of ownership merely because you've been paying taxes.
We got this question, an email question from Brett. Brett wrote in, I was in a car versus truck wreck. I was struck on the driver's side and then rolled the car. I've got injuries and my car is totaled. The other driver was cited for inattentive driving. What are my options?
Well, first off, if the other driver is cited for inattentive driving, then probably they're not paying attention to what they're doing. That's just what that means. And in Alabama, you have an obligation to pay careful attention when you're driving, to keep a safe lookout, to follow the rules of the road. And if you don't, and you hurt somebody, then you can be responsible for that conduct. And also, you can be responsible for the payment of the repairs of the vehicle, and in this case, it's a total loss, which means the car's not worth as much as the repair, so you get the fair market value for your vehicle. So your options are in that kind of situation is, first off, work with an attorney, get your property damage taken care of is what the first thing that needs to happen is. And then as you're moving on from that, you want to make sure that you're getting the medical care that you need, that you're going to the appropriate doctors, and you're making sure that you're getting better. And oftentimes, if you have a lengthy personal injury sort of claim like that, it pays great dividends to contact an attorney early on so that we can gather the evidence, secure the area, make sure we have and you have what you need to get the recovery you should get in a claim like that.
We've got Mildred on the line with a question from Huntsville. Hi, Mildred. Thanks for calling. What's your question tonight?
Yes, ma'am. I want to know if I can get this person off my deed. I put him on December, and I want to know if I can get him off my deed.
Is he, I'm imagining he's not going to want to cooperate, right? He's not just willing to sign off?
I'm not sure.
Okay.
Well, the quickest way you could do that, first off, that's a real estate issue. You probably want to talk to a real estate lawyer about that. But generally speaking, what you could do in that kind of scenario is you could get him to give you a quitclaim deed, which means that he would sign over any right he may have to your property in that quitclaim deed. I don't know what the circumstances are for you that you put him on the deed, whether he gave you some sort of consideration for it or whether he gave you false information to get put on that deed. And those could be some avenues that you could talk to an attorney that does real estate work that could maybe help you out. But a quitclaim deed is the simplest way to get him to sign to say he doesn't have any right to your property.
And you don't have to have any kind of surveying done to do that. Simple, cheap version. If he'll sign it, that's pretty cheap.
Any right. And here's one I wanted to talk about. This came in. Is a transfer on death deed available in Alabama? That's a joint tenancy with a right of survivorship.
So yes.
So yes, it is. Joint tenancy with a right of survivorship. You can put that on your deed. When you pass away, your land will pass immediately outside of your estate.
We're going to take a break. Be right back.
by Timberlake League and Brooks, which pays an advertising fee to this station.
If you didn't get your questions answered tonight, here's how to get in touch with Heath Brooks with Timberlake League and Brooks in Huntsville, 256-536-0770 or 800-804-2502. The website is law-injury.com. And if you like them on Facebook, you can learn more about the law that way.
And if you need to get in touch with Sharon, she does family law, child custody, divorces, and things of that nature. She can be reached at 256-539-7337 or www.sharonfamilylaw.com.
We were talking about Bo's Law, the new Bo's Law. That can be pretty serious.
I forgot to mention this. Class C, B, or A felony. The first offense is a Class C, which is the misdemeanor, the lowest misdemeanor, but you could go all the way up to potentially up to a year in prison if you violate these laws. So it's tough. Good law and good night, Huntsville.
Thanks for all your questions. See you next week.